Hello learners, I am Dr. Lata Rani. I am working in Delhi Skill and Entrepreneurship University as an Associate Professor and Program Anchor of Banking, Financial Service and Insurance Department. In today's lecture, I would be talking of the another aspect of free consent, which is misrepresentation. You would be able to learn what is misrepresentation, how that affects the consent of the party, and we also would like to have our discussion towards fraud, where I would be covering up the difference between these two parties. First, let us start with what is misrepresentation. Misrepresentation is when a party is providing a false assertion or a fake representation of the fact to another party or making unwarranted information to mislead the other party. According to Section 18 of Indian Contract Act 1872, the misrepresentation is nothing but showing the false information at the beginning of the contract itself. The facts which are committed at the ground level may not be reliable, resistant, and then it is considered as misrepresentation. So very importantly, we have to know that misrepresentation is when somebody is providing a false information to make a contract. So you could have one example so that you be able to understand what misrepresentation is. When A is saying to B to purchase his car which is in a good condition, and B purchased in a good faith, but after some days the car did not function properly and B has to suffer a loss to repair the car. So he has to get the car repaired and incur amount on the repairs. So this act amounts to misrepresentation, as A believed that the car works properly, but this is not so. So it was concluded that it is in a good condition, whereas car is not in a good condition. Just after some days of the contract, they had to conduct repairs and expenditure was huge. So misrepresentation is any fake representation of the information which is provided by one party to another party is a case of misrepresentation. Misrepresentation means and includes all three things. Number one, the positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believes it to be true. So it is just a positive assertion, like if you are giving it as it is true, though it is not true. So that is not at all truthful information, but you give in a positive manner where person believed that it is to be true. So misrepresentation is when just take the example of Speak Asia, that company has given that information which was not true. So you be our member, pay us 11,000 rupees as a membership fee. We are going to create a sample survey for you. Every month, if there are 4 weeks or 5 weeks, we would be sending you survey and you would be getting 1,000 per survey. So people have compared it, that if I am giving it as 11,000, on an average I am getting it as 50 to 55,000 per year, which was not at all true. So it is positive assertion that you will get, you will get, you will get. So if any kind of offer you see of any company, of any brand, and later on you enter into the mall by looking at that offer and they say this offer is not working now, it is something they have given a wrong information, untrue information. Second is any breach of duty, which without intent to deceive gains an advantage to the person committing it or anyone claiming it by misleading another to the prejudice. Yes, if you are breaking your duty, whether you have an intention to deceive or not, to cheat someone or not, but you are gaining the advantage because of that breach, it is case of misrepresentation. Third, a causing, however innocently, a party to an agreement to make a mistake as to the substance of the thing which is subject of the agreement. So you are causing that party in under the domain of mistake. What are the different characteristics of misrepresentation? Number one, it should be mentioned that the false statement was of material fact, not mere words. It has to be proved that the material information, important information, pivotal fact has been shown as a false statement. Second, when a party makes a misrepresentation to the other party, it should be proved that I have believed on that information. I believed that that fact is true. And third, the party should have misrepresented the facts to induce another party to enter into a contract. So all these features must be present to prove it is a misrepresentation. What are the different kinds of misrepresentation? Let us understand that. One is negligent misrepresentation. Second is innocent misrepresentation. Negligent is when it is actually a misrepresentation due to lack of reasonable grounds or carelessness part, that you are actually not knowing to that fact. So negligent is when a representative is giving the information and you believe it as true. So person would be liable if he had neglected the duty mentioned in particular scenario. So relationship and the responsibility exist between these two parties when there is no fiduciary relationship. So negligent misrepresentation is when any reasonable ground or carelessness has been lacking in the contract. So you are negligent to collect the right information. So somebody provided you the information, you relied on that information and you have not put your efforts to make sure that is wrong information or right information. So like we are aware that if any call is coming to have a scammer from your account perspective, from your credit card perspective, bank and authority time and again tell you that we are not responsible for such calls. Do not provide your OTP and passwords or any information pertaining to your account over the call. So negligent is when you are not aware of it. So because of your careless attitude, you believed it as true. So that is where negligent misrepresentation is there. On the other hand, we have innocent misrepresentation. When the representation is based on good grounds to believe and it lacks negligence and fraudulent information, then it is said to be innocent. You know, every time collecting the information is not the approachable. So we could have those areas where we cannot see the information in an available form. Like we could witness that we have certain areas which are very remote, which are part of like remote areas of Bihar, remote areas of Jharkhand, right? In those areas where people are innocent and they believe whatsoever is coming is right. So they don't have available sources to check for the information. They don't have available education to check for the information. Then that kind of misrepresentation falls under the category of innocent misrepresentation. So when a person enters into a contract with innocent misrepresentation, it has a right to revoke the contract, but it is not entitled to any kind of damages that he has suffered. A contract won't be void unless reasonable grounds are provided. You know, you have to have certain reasonable proofs with you to prove it was innocent misrepresentation. Proving innocence in a misrepresentation would be sufficiently enough for this fact. So, innocent is when they are believing it as true and it lacks negligence and fraudulent intention. Section 18 includes three types of misrepresentation. One is through the unwarranted statement, second, breach of duty, and third, mistake about the subject matter. Let us understand what these three types of misrepresentation are. Unwarranted statements are when a person asserts that the particular information is true, though it is not true, though it is false. This is a misrepresentation. So, a warranted statement is a statement when the person making the statement receives the information from a trustworthy source and there is no hearsay. So, that is why when you are collecting or googling any information, you have to check it out. Is it a secured HTTPS? When the word S is written, we believe it is from the secured resources. Otherwise, there are information which are being passed as it is true, though it is not true. So, unwarranted statements are like that. So, when you are not checking the authenticity of the information and you believe it is true, which is actually not, this is actually known as unwarranted statement. Second is breach of duty. Breach of duty means break of duty, violating the rules, regulations, terms, conditions of the duty. So, any breach of duty which brings an advantage to the person committing it by misleading the other person is a misrepresentation. So, this clause is intended to meet the cases of constructive fraud, where there is no intention to commit fraud, but circumstances are such that the party who derives benefit is equally responsible as he had done by motivating someone to fraud or deceit or cheat. So, breach of duty is when you are trying to take the benefit from that situation. Third is mistake about the subject matter. Causing innocently a party to an agreement to make a mistake as to the substance which is subject matter of the agreement is also part of misrepresentation. But it should be kept in mind that the misrepresentation should be of material facts, important facts, and not of mere facts. Misrepresentation of any subject matter which is not of much relevance will not help the person to avoid the contract. So, fact which is important, which is vital, which is material is when it affects the decision of a reasonable person to enter into a contract or not to enter into a contract. So, that is where misrepresentation is lying. What is the effect of misrepresentation? When the party who has suffered due to the misrepresentation while entering into a contract can opt to cease the contract, stop the contract. There are two remedies which are available to the party, that is resigning the contract or claiming the damages. Resigning means cancelling the contract, not to perform the obligations of the contract. And the claim of damages means the contract is left intact and party is subjected to claim the damages that has been suffered during the contract. Suit for rescission is there to seize the performance of the contract as to restore the party to the original position as if there was no contract. So, these two rights and remedies are available in the hands of aggrieved party. Let us look at certain cases. One case where Shashi Mohan Paul Chaudhary versus Novo Cristo Powder In this case, a person bought a quality of rice, was prevented from alleging misrepresentation regarding the quality of price as he lives very near to the place where goods were lying and have a reasonable opportunity to discover the truth with reasonable diligence. So, where the truth cannot be discovered with ordinary diligence, the party guilty of misrepresentation cannot rely on the defense. But when it is very near, you could go, you could check out the quality of the rice, then court believes that you have a reasonable diligence to check the quality. So, here misrepresentation was not being imposed. Another case, Bindu Sharma versus Ram Prakash Sharma. In this case, it was held that in matters of matrimony, qualification of a spouse is of immense importance. And if you are hiding that, it is leading to the misrepresentation. So, in this case, the qualification of one party was being hidden, and it was given that he or she has qualified this particular program, this particular graduation or post graduation. So, court believed it is one of the important material fact that you have hidden. So, in that hidden part, they have believed it is a case of misrepresentation. Very important aspect, that is fraud. When we talk of fraud, it is when we have an intention to cheat someone, deceive someone. So, another important aspect and factor of free consent is fraud. When any person provides false information, false assertions, make wrong promises to cheat a person or plan to get an advantage over the other party, then this act is considered as fraud. So, fraud means complete omission of the promises made during the agreement, the false assertion of the facts, false actions to cheat the another party, and many more deceiving actions come under the fraud. According to section 17 of Indian Contract Act 1872, the other party has been given rights to claim for the deceived amounts as well as revoking the entire contract as well as claiming the damages. So, what is fraud? When you have an intention to cheat someone and you are giving wrong promises, all those promises is not being fulfilled. So, if any person is saying that you buy this flat and I am going to give you this television as a free, fridge as a free, ACs are free, or modular kitchen are free. So, on those basis of those promises you enter into the contract. But once the flat cost has been taken up from you, registry has been done, he denied, he had not given you any kind of that facility which was promised. So, this is a clear cut case of fraud. So, look at these examples. A purchased goods of rupees 5,000 from the shopkeeper B with an intent of not paying this money. So, he has purchased the goods, but he has an intention not to make the payment. I will pay later, I will pay tomorrow, I will pay next month. So, when you are not paying it, this type of act is fraudulent. On the other example, A agrees to sell his horse to B. A had the knowledge that the horse is of unsound mind, but he has not informed it to B. B asked A if he does not deny the fact, B would consider the horse to be sound. A kept silence to it. In this case, mere silence amounts to fraud. So, you have to speak that my horse is of unsound mind. If he is asking you and you are keeping quiet, you are keeping silent, you are keeping mum, in that case it would be leading to fraudulent acts. What are the different features of fraud? Number one, when any party conceals the fact from the other party. So you are concealing, you are hiding certain information. That information is of importance, that information is of pivotal nature, number one. Number two, when any party promises to perform an act or series of actions, but he has no real intention to fulfill those promises. So that is also causing fraud. Third, any false representation of the facts has been made to enter into the contract. So you are actually giving wrong information, false information. If you are omitting any action which is considered to be fraudulent in the eyes of law. So you were supposed to disclose that information, but you have not disclosed that information. That set of information is not disclosed. Then in that case, it is a characteristics of a fraud. So fraud may be seen in a very normal scenario where you are getting a call and they are saying, sir, you have won a car, and this car you have to get it either from our showroom or we will be dispatching it. But for the processing of car documents, we are taking 20,000 rupees. So eventually, by lure of car, you are giving all that 20,000 to their account. So what happens? Afterwards, their phones are switched off, car is not arriving, and you are not able to trace where this amount has gone. So this is a clear-cut case of fraud. What are the effects of fraud? The contract raised out of fraud is a voidable contract. You have to speak against that contract. It is in the hands of aggrieved party to either take away with the contract or cancel the contract. The party deceived has a right to revoke the contract. Revoke means cancellation of the contract, declining the contract, resigning the contract. Third, the party is liable to cover the damages due to fraudulent contract. So they can claim the compensation, the damages from the defendant. Mere silence to facts is no fraud. Yes, mere silence to facts is not fraud ordinarily, even if it results in the concealment of facts likely to affect the willingness of the person to enter into a contract. So if he is not a party to the contract and he is not speaking in favor or in against of the contract, then this kind of silence is not leading to fraud. Both the contracting parties are not under any obligation to disclose the whole truth to the other party. It is the party who has to see that the information is true, genuine and fair. Silence may become deceptive when these four cases happen. Otherwise, mere silence to facts is not a fraud. So, duty to speak, that is case of Ubrima fights. Let me explain all these 4 points in detail. Number one, where you were supposed to speak and you are not speaking. So, duty to speak is first such case where silence amounts to fraud. So, it was you who was handling that contract. So, you had to speak. When you are under a duty to speak and you are not speaking, then this Ubrima fights come under fraud. Let's take an example. You are going to settle down a case with a property dealer to purchase a particular property. You went to the bank and you have shown the property document and asking the banker if this property is already mortgaged or not. Now, as a banker, he is under the duty to tell you the mortgage history of that land. For example, banker is quiet, banker doesn't speak anything, where banker is supposed to speak, where banker is under a duty to speak and he doesn't speak. And later on you enter into a contract, you came to know that yes, it is a mortgage land and I have suffered a huge loss. Then banker will be charged as per fraud. Take an example, father while selling a horse to his son must tell the horse is unsound because son is likely to depend upon the facts given to him by his father. So, father had a duty to speak. Second, where silence is deceptive. Silence of a person sometimes is equivalent to speech. A person who keeps silent knowing that his silence may be deceptive, then he is considered as guilty of fraud. Half truth. Even if a person is under no duty to disclose the fact, he may be held guilty of fraud when he voluntarily discloses half of the facts and stops half of the way. So, the non-disclosure of remaining half will amount to fraud, as you were not under a duty to speak, but you have given half information and you have to disclose the full information. In both the cases, it comes under the fraud. Change of circumstances. Sometimes a representation is true when it is made, but the passage of time, those information become false. In such cases, a person who made the representation to communicate the change must be giving the right information over a period of time. So, like legal provisions, legal laws, legal system is getting updated. So, as a lawyer, he must tell you the change of any law, of any provision. But if lawyer does not speak, then it comes under the fraud activity. A legal practitioner represented to the plaintiff that his practice was worth $2,000 per annum. The representation was true when it was made 6 months ago, but its worth declines due to the defendant's serious illness. Hence, the defendant is under a duty to communicate his decline in worth after 6 months due to his illness. If he does not disclose it, then it is a case of fraud. I would like to draw your kind attention to this case particularly, where it is proven that the information was given under the fraud activity. Dairy versus Peak. In this case, a company issues a prospectus that contains the information, and company is authorized by special act of parliament to run trams by steam or mechanical power. But the authority was subject to the approval of Board of Trade, and later on board refused consent, and consequently company was wound up. Plaintiff who purchased the share on that information that my company is running by steam, by mechanical power, then those shares were taken up. But they were not held liable, as there was no intentional misrepresentation of the facts, right? So, Board of Trade declined it and company wound up. So, company didn't get a time to inform to the prospective investors regarding the same. Difference between fraud and misrepresentation. One must know, when we talk of concealment of information, representation of information, one must know what is the difference between fraud and misrepresentation. First difference is of meaning. Fraud is a deceptive act intentionally done to influence the party to enter into a contract. So, it is like providing the wrong information, doing everything on an intentionally form, and you are believing that information is right. Whereas misrepresentation is representation of a misstatement made either innocently, which persuades other party to enter into a contract. This is defined under section 2 subsection 17 of Indian Contract Act 1872, whereas misrepresentation is defined under section 2 subsection 18. Now, what is the purpose of this contract? Fraud has a purpose to cheat the party, whereas misrepresentation may or may not have that purpose to deceive the other party. Variation in extent of truth. In a fraud, the party making the representation knows that the statement is wrong, that the statement is not true. Whereas misrepresentation, party himself believe that this information is true, which turns out to be false later on. Claim, yes, aggrieved party has a right to claim for the damages under fraudulent cases, whereas under misrepresentation, he has no right to sue the party for the damages. They can revoke the contract, resign the contract, cancel the contract. Voidable, yes, under fraud, the contract is voidable even if truth can be discovered in normal diligence. Whereas in misrepresentation, contract is not voidable even if truth has been discovered in the normal diligence. So, I would like to conclude, we must know that the consent obtained through these fraud, misrepresentation is not said to be free consent. We must know the contract and the establishing relationship under these various circumstances, whether that is coercion, whether that is undue influence, fraud, misrepresentation or mistake. Thank you learners. Keep learning and keep enjoying. Thanks.